All right, it's time for our favorite podcast, Cut to the Chase. You know this face. Yes, you do. Michael Burns. Mike, how are you doing?
I'm doing great, Greg. Thank you for having me on. And I'm happy the Mother's Day belated to your mom down there in South Florida.
You know it. Thank you very much. And I did tell her before that, on Mother's Day that you were coming on, brought a smile to her face. All right. She's like, go, Mike. I won't use the word she said, but you got the gist of it. Okay. 3M updates. It's been a while. I'm sure there's a lot of plaintiffs out there that are like, like what's going on. They haven't heard, they're hearing from their lawyer. They don't understand what's going on. So we're going to try to break this down into three parts that I think most of the plaintiffs are either aware about or need to be aware about and can understand in this short time span that we're going to spend talking about these very complicated issues. What's going on in the bankruptcy? We the first cases actually have oral argument in the appellate court. Okay. And then there's some talk about settlement. I'm sure everybody wants to hear about that. So let it roll, baby. You're on.
Sounds great, Greg. And I'll chat with everybody out there in podcast world, just like I do when I chat with my clients and breaking it down. We just had the motion to dismiss hearing trial in front of Judge Graham up in Indianapolis. And that basically took 2 weeks to do that. And Judge Graham asked for an extension of time to make a ruling on that. Usually he makes that ruling in about 15 days. And I think, Greg, that's been about how far we've been out since the trial date. So I expect to see a ruling from Judge Graham out in Indianapolis in the next couple of weeks on the Aearo bankruptcy, where he may decide that Aearo can continue to proceed in bankruptcy court, or he could decide, hey, this is a farce, and we're going to go ahead and kick all these cases back to the MDL, the multi-district litigation in front of Judge Rogers down here in Pensacola, or LA as we like to call it, Lower Alabama.
Yeah. All right. So before we go on to the appeal, so it's right now where there's bankruptcy, and so that stops all the other cases from going forward. No trials, no discovery, no statements, all that gets frozen, right?
It does. And Greg, if you've noticed, Judge Rogers has kind of broken it down a little bit. There's at the time that the bankruptcy was going on, and just as his motion to dismiss trial was going on, there were 231,000 plus cases in the multi-district litigation that were impacted by this bankruptcy that was filed by Aearo. Of those cases, 23,000 and some change are 3M cases, and the balance of the 201,000 are Aearo cases. So what Judge Rogers has done is even though everything stayed, she's getting ready to roll based upon what the 11th Circuit may do, what the 7th Circuit may do, and what the bankruptcy case is doing. So she's putting things in motion and getting ready to go based upon what these other appellate courts and what the bankruptcy court look like they're going to be doing and issuing rulings in the upcoming weeks.
All right, so let me make sure I got my facts straight. Aearo, 3M. Aearo was the original manufacturer of these earplugs. That company got bought out by 3M. So the lawsuits have been going against 3M and Aearo. And during the lawsuits, 3M and Aearo are both represented by the same lawyers.
Correct.
They've all announced on the record that 3M is the party that's responsible. And,
exactly, Greg. Good point. Good point that you made.
And Aearo is the company that filed for bankruptcy and asked the court to stop all the litigation and give the bankruptcy protection to 3M. And that was denied by the court. And that's what the bankruptcy appellate court is deciding on right now.
You're absolutely correct, Greg. That's correct.
Okay, so the two options are they agree with the lower court's ruling and they say 3M does not have this protection, or they say that 3M does have that protection. Give me how the two different basic rulings. I mean, obviously the court can come up with something else or something close, but just simplifying it as much as I can. Those those two options, how does that play out?
That is two options, and that's what you have right now in the Seventh Circuit, is whether or not 3M gets bankruptcy protection, even though they did not file for bankruptcy in the Indianapolis trial court, bankruptcy court. So that's what's up on appeal, is whether or not 3M gets that protection where everything is stopped as it applies to the company, both 3M and Aearo. So we're waiting to see what happens there. So also what was going on at the same time is the plaintiffs in the case or in the MDL filed a motion to dismiss in the bankruptcy case against the defendant Aearo, saying that, look, these guys are a sham here. This is not a real bankruptcy. They're not in any peril. They've got plenty of money. They haven't defaulted on any creditors. The only way that they put themselves in peril is that they signed this funding agreement back in, I believe it was June. It may have been July of this year. Excuse me, last year. And that's the only thing that's put them in peril. However, what plaintiffs are saying, well, they're still not in peril, because 3M has agreed that they would indemnify Aearo for all the damages and anything that they would suffer in that particular case. The thing that Aearo may have to do is they may have to spend down their cash on hand to $5 million before 3M has to start contributing money to them. Now, one of those so-called debts that they have out there is a little over $960 million. And I know, Greg, you read this in the transcript to the bankruptcy motion to dismiss. That's a debt that 3M owes to Aearo, and they haven't collected that money. And their position is, well, if we collect that money right now, then 3M would require us to spend that money to resolve these cases or whatever before 3M would have to kick in spending any of their money. So that's why they're claiming they haven't collected on that debt that 3M owes them right now.
All right, so that's pretty advanced. I wanted to go back to the two options. So if the bankruptcy court agrees with Aearo and 3M, then we're all in bankruptcy.
We're all in bankruptcy.
And then at that point, I guess they propose a plan, and the clients would have to vote yes or no, and that whole process.
You got the gist of it. If the court says bankruptcy applies to 3M and Aearo, then those cases all stay in the bankruptcy court, and that's where everything gets resolved.
All right. And if not, then the case goes back to Judge Rogers, the trial judge, and that's when she's going to implement the plan that you just referred to, which is to send a bunch of the cases out to the courts where they originated and to start the trials again and the depositions and the discovery.
She could do that. And, Greg, the litigation has progressed, we've seen that Judge Rogers has set up waves 1, 2, and 3 in the cases where she's grouped a number of cases, say 500 cases at a time, to be in a particular wave. So she's required the parties, both the plaintiffs and the defendants, to get those cases ready for trial. So if she's going to pick any cases to go back to those jurisdictions where they rightfully should be tried, that would probably come out of that wave 1 case first. And so the question is how many of them does she send back? Does she send back all 500? Does she pick a group of 50, 25, whatever the number is? But that's likely what would happen, is that she would get ready. And then the other thing that we've seen Judge Rogers do is she's always proactive. She's always, this litigation, we've been in the middle of COVID at times. She kept a schedule, and that's what she does. She keeps that schedule. So the one thing that she's done in this litigation, in the MDL, and also in the Minnesota State Court litigation, is both of those judges have appointed special masters to oversee the mediation process, and that's Judge Herndon in the multi-district litigation. Judge Herndon's from lives in was in Southern Illinois as a district court judge, and doggone it, I'm forgetting the name of the judge up in Minneapolis, but he's the magistrate judge from up there. So those two judges are ready to go based upon whatever happens in the bankruptcy, so that things can start to progress. And like I said, Judge Rogers has ordered that mediation and mediation attempts are set in motion to get these cases resolved, even as we speak.
Yeah,
so she's on that to make sure that happens.
So the mediation is a formal process where authorized people with authority to settle from both sides have to meet, and it's this Judge Herndon and the other judge that are going to basically be in charge of the mediation. The theory being Judge Herndon is a no-nonsense. You're not going to get away with bullshitting this judge when in negotiations, and with the hope that the judge can get the parties together and get something done.
Exactly. Judge Herndon, big baseball fan, St. Louis Cardinals, that's his team. But he was appointed to the bench in the late 90s at the end of President Clinton's, Bill Clinton's term. So I think Judge Clinton was on the federal bench from like 1998 until maybe 2019. So he spent a little over 20 years as federal judge in the Southern District of Illinois. He may have been even the chief judge at some point up there.
That's Herndon, Judge Herndon.
Judge David Herndon, that's correct.
Yeah.
And Judge Herndon was also the special master in the multi-district litigation to help resolve disputes amongst the parties as we were going through the trial process. So he would help referee both sides of issues that were coming up, so that he could kind of streamline the process. And if the party still had an objection, those objections would go up to Judge Rogers. But Judge Herndon work with the parties to resolve issues all through the trial process, all through the bellwether trial process. So he is extremely familiar with the process and all these cases in the MDL.
Has there been a date set for the mediation?
Not that I know of so far. If I do that, Greg, I'll make sure I let you know.
Okay, yeah. All right, so the third part is the appeals, not the bankruptcy appeal, but there were 13 victories from the veterans and 6 losses. Each one of the veterans that were victorious, no one's received a dollar yet, because 3M has taken an appeal on each one of these cases. I won't get into how much they've spent on their lawyers. Okay. I mean, listen, we're talking about veterans, but hey, they're going to pay their lawyers, and this funding agreement nonsense you were talking about, but we'll set that aside for the moment. All right. So now the first round of appeals, they had oral argument, which happens. The parties write up their arguments, they brief everything, and then the judges get together, and the attorneys get there, and they argue, make oral argument, blah, blah, blah. And then typically after the oral arguments, the appellate court will make a ruling.
That's correct. That's correct, Greg. And those happen the first weekend in May. And so we're approaching Memorial Day, which many of our veterans that served our country and gave their lives knows that's coming. Their families know that's coming up, not this week, but the following week. But yes, there were 4 appeals that were held. The consolidated trial, EHK is what we call it. Estes, Hackle, and those were the 4 cases that, and then the Baker case was a standalone case. So all those cases went up on the government contractor defense, and those cases went up to be heard before the 11th Circuit. And like I said, the 11th Circuit that sits in Atlanta, they heard those cases in Montgomery, Alabama, at the first of this month, and hopefully we're waiting to get a return on that. And then of course there's another one that's up on appeal, which is a successor liability case, but that has not been ruled on by the 11th Circuit. But hopefully we'll get a favorable ruling in that, and some clients get some payment on those judgments that have been entered but have not been paid thus far.
What's the total amount of those for?
Well, I think if you added them together, it's going to be just a little less than $10 million. Because
Okay, all right. So if 3M loses, they could be writing a check for that amount of money,
yeah, just
unless they take it up to the Supreme Court.
correct. And it's just south of $10 million.
All right. So you referenced the government contractor defense. We've gone over this on a couple of shows. The government contractor is a defense, which is essentially like, hey, the government contracted us to make a product. We followed the contract. Sorry, it didn't work out. Our defense, we're not responsible because we followed the contract. Right?
Correct. It's one of those ones like the devil made me do it. The government made me do this. They set the specs. They made this, and we had to do it. And so it should be ollie income free because we just did what they made us do.
Okay. And from what I understand, there is no contract.
That is correct.
Okay. So it doesn't sound like I'm not going to, I know.
I know, me either, Greg.
I'm not going to say anything, but all right. So I think if they lose that and there's no contract and they take an appeal to the Supreme Court, I don't see that going anywhere, but you never know. I mean, maybe we're not, reading their briefs and their arguments correctly. Okay. So I think that kind of covers it. So, listen, they might be paying out money to some of the victorious plaintiffs, and there's 9 others that are waiting their appellate, the final result in their appeal. And if the bankruptcy court comes back down, there could be some cases that go to trial by the end of the year. They might be paying, they keep losing, at some point, maybe they decide they want to settle or whatever. And now we're going to mediation with Judge Hearn and maybe we settle. But I want to conclude the show on 2 notes. First of all, it's come to my attention that I identified another listener of Cut to the Chase.
Oh.
And that apparently is 3M. So
yes, indeed.
so what I heard was that they referenced the show at that 5-day trial in the motion to dismiss, and actually took the transcript of one of the shows and attached it as an exhibit, along with a few other podcasts.
Yeah, you're absolutely right, Greg.
Yeah.
To the Chase made its debut in bankruptcy court up in Indianapolis. So not only is your mom one of the biggest fans, but 3M was a fan of the show as well.
All right. Now, I was thinking about, I actually couldn't sleep last night thinking about this one particular question. Do I want to invite them or one of their representatives onto my show? And I think I should. I'm inviting anybody from 3M want to come on my show, tell me that we're not seeing things properly, or the case is not good, or all the victories were, the government contract defense, or they're really in financial distress, or whatever. am I going to regret this, Michael? I'm inviting them. No, I'm not.
I can say this, Greg, I wear blue because my wife says I look good in blue, but if you want to wear blue, you might be holding your breath a little bit before they accept your invitation. All
right. Well, it's out there. It's officially out there, maybe attached to another court proceeding down the road when, whatever, admission by silence. I don't know, right? They were talking about the hearsay and statement against the party's interests. When you're an attorney, you can't talk about your case or whatever. Okay. And then the last thing is, I love doing research. And one of the things that I do some research on are my guests. And I said, you know what, I shouldn't just accept Mike's representations to me about, his skill set, his, all of his talents, his injury history and all that. So I did a little Google search, and I just want to say, I found this, okay, on the internet, and I was like, wow, who's that guy in the white helmet? He kind of looks familiar. And then I'm like, if you ever see a guy out in the lineup with a white helmet, it's probably local attorney Mike Burns. This is on the Pensacola Surf website, Flashback Friday with Tom Hudson. Mike had a pretty horrendous surfing accident years ago when his swallowtail landed, quote unquote, in his forehead. It was basically drowning. He survived. But if I'm not mistaken, he was told never to surf again. Well, he's still surfing all the time with his helmet. Here he's taking a clean slice out of a wave in Central America. Would
had
you
to
like to
dig that one
comment?
on, Greg.
Would you like to comment on that one? And his
God,
head,
you know, I just feel really fortunate to be able to still serve today. And hats off to my doc back then, Dr. Jack Lurton in Pensacola. I was probably one of his prized patients. But yeah, he didn't want me back in the water, but I think he knew I was going back out there. So it's kind of like it's in your bones,
Yeah.
As Janet Kennedy said, there's something about that salt water that draws a man to the sea.
Yeah,
So,
yeah, no.
there
I
you
can
go.
see that. I can see that. Well, that'll do it for this episode of Cut to the Chase. If you have any questions about what's going on, feel free to, give me a comment, ask questions. We'll do what we can. All right. And Mike, get out there.
You never know what you're going to get when you watch the Cuts to the Chase, but it's entertaining. Yeah. Thanks again, Greg, for having me on the show. And I look forward to getting back with you with updates in the near future.
All right. That'll do it, folks.